opening direction. It is part of how we tell the parties we are going to proceed. It is purely at the discretion of the mediator as to whether or not a caucus would serve any good. So I was kind of surprised to hear that you could not go to caucus here if the parties don't want. Our parties know up front, the lawyers are aware of it, that if the mediator thinks that there's benefit in caucusing, that he would separate the sides and so on. I'm sure that we have had people who would have done mediations where you did not necessarily caucus with both sides. That's the contribution. Thank you.
Excellent. Thank you.
I suppose we are taught here that the disputants are in charge of the session in terms of where they're going, so we allow them to make the choice and give the guidance. Who's taking the mic? It's dropping one, dropping two, dropping.
Dropping thrice. Listen, team, let me go a position where I could see everybody. We were given an assignment, and the assignment simply says, basically, you are going to argue that you're going to go to caucus. Now, not everybody in the group agreed with going to caucus, right? But the assignment basically was, you're going to caucus and tell us why you will do so. So we'll take it from that perspective. First of all, when you look at the case, you will realize that the parties are fixing their position. That is, if you're looking at the case, not in the presence of the people, but reading the documentation. This is the documentation you provide with me. So these people seem to be fixed. One is saying, I want my money, and the other person is saying, I'm not going to pay you that money, right? I want the retain or whatever that the money is, right? Okay. So they seem to be fixed. So we're going to go to caucus because if the positions come to us that appears to be fixed, we want to try to identify exactly why the parties have adopted their positions. And in having that discussion, as they talk about it, the mediator is in a better position to be able to treat with the whole mediation process. There's another part of it that you find that we'll get a chance to clarify obligations that the individual parties may have. Right? For example, other obligations, I mean, you know of obligation with the particular case, but there may be impending obligations and so on. And the mediators sometimes need to understand all of that clearly. And sometimes even if you read the contract and so on, you may not really get all of it because you may not be a contract lawyer, you're just a mediator, you may not be a full expert in that area as the case may be. So you may have to sit down and have conversation. In terms of, tell me this, answer questions for me so that I would understand clearly what you are saying and what your position is, how you arrived at that and why you're at that position and so on. Reasons for going to mediation. The mediator can get to the hidden issues as to why the parties are fixed in their position, the caucus rather, fixed in their position, right? And then treat with, as I said, outside issues and so on, substantive, issues outside the substantive matter, right, of the mediation itself. Now, and that's basically what I'm hearing from the group, those basic things, right? But you threw us a curveball, and we didn't get to discuss the curveball fully, right? Now, I interpret this, I had to say I, because I had to sit down and read it and give you an answer, right? Because we don't have a chance to discuss this fully. Now, how I understand this is that we were caucusing, and while we were caucusing, we realized that the party didn't understand some of the wording and terms and so on of the contract, of the agreement they're going to sign. What I was taught as a student mediator is that we're not allowed to give advice. Therefore, I will give the option in open group, both parties together, sitting together, and say to them, listen, because, of course, getting permission from the other party, to say this openly, right? Because the terms of the agreement that we are going to sign is not quite clear on both sides, I would want to suggest that you engage the services of your technical personnel or attorneys at law to go through the terms of the contract with you before you sign, and we can come back at another date. Now, that's based on what you give me here. So that's how we're going to treat with that, right?
Thank you,
Thank you
very much.
Right.
Groups 1, 2, 3, 4, everyone. I do apologize for the time constraints we're under, but the chairman is up next, and he has the room from 1:30. So, unfortunately, lunch overran a little bit today. You have just been given some forms. Those forms to be filled out, please, so that they can assist in future symposiums by the mediation board. Any comments, any useful comments, we'd be very grateful.
Let's say the usual. Any closing remarks? Yes?
I have one comment on group 4.
Uh-huh.
On group 4, sorry.
Group 2.
The scenario 1, with those who did not want to go to caucus.
Uh-huh.
I got the fact that the wife wanted to sell the shares to the caucus. In fact, indicated that she was on a revenge path and putting the revenge motive in front of the interests of the children. And that maybe they should not have yet gone to caucus or go to caucus to give her more of a chance to vent and get over that emotional hurt. And I thought that they should have included that as part of their strategy, not to caucus.
So we started off the day with yes or no, and I think that's how we're going to end, yes or no. We'll agree to disagree. All styles are effective. Everyone has their own unique style, and we're very much appreciative of all your feedback today, your comments, and Dr. Niles?
Well, I think that one of the things we recognize in here from the Panchayat perspective is that we do have cultural perspectives, sir. And whether they are gender-based or identity-based or power-based or rights-based, you are going to have the need to, as a mediator, to make sure that you don't infringe in terms of the sensitivity of your disputants. Otherwise, you are going to really have to say deal or no deal and have more than one caucus which just a mash of the mediation. So be aware, be sensitive, and be so directed in terms of how you are hearing what you're hearing, which has to do with your own position. So clearly redefine that in terms of the way forward. Otherwise, this would not be a TV show. You'll lose your $250,000 and get zero. Okay. Thank you very much and have a good afternoon.
Thank you.
Listen, don't go yet. You have the chairlady.
Thank you very much for this really enlightening and entertaining and lively session.
Thank you.
And as has been said, every mediator has a style. Every circumstance is different. And it is really according to what is happening in the room at any time. But the thing we must always be conscious of is that the parties, the process belongs to the parties. You know, so I want to thank you very much. And we did quite well, did a lot, and on time. Thank you very much. Thank you, ladies and gentlemen. Please leave your forms